Hello. Should we start?
Yeah, we can. Like get set, ready, go.
No, no problem. Hello, a very good evening to all of you. As we all know, that courts have played a salutary and a vital role in innumerable instances. They have practically tried to wipe away every tears of the underprivileged, disadvantaged, and illiterate sections of the society. And while doing this, they have even been alleged to cross the Lakshman Rekha of the separation of power. Thus, in this way, the acknowledgement of this difference between judicial activism and judicial overreach and restraint become essential and vital for the smooth functioning of the constitutional democracy. Thus, with this view, to analyze the real existing problems in the debate between judicial activism and judicial restraint, today we are privileged to have with us a chief guest, Honorable Mrs. Justice Gyansudha Mishra, and a key speakers, Mr. R. Venkataramani and Professor Dr. V.C. Vivekananda. I wholeheartedly welcome all of you. I also welcome all the participants on behalf of NEEF Judicial Education. Ladies and gentlemen, our speakers scarcely need any introduction, so I'll keep this very brief. Honorable Mrs. Justice Gyansudha Mishra is a former Judge, Supreme Court of India. Justice Mishra was elevated as Judge of the Supreme Court of India on 30th April 2010. She has passed several landmark and notable judgments in the Supreme Court of India, including judgments on conflict of interest in Srinivasan BCCI matter, landmark euthanasia judgment in Aruna Shahbag matter, and most recently in Delhi Upahar fire tragedy dissenting judgment, holding the management liable for colossal loss of human lives and directing them to pay heavy compensation to be used for social cause like building trauma center, etc. I welcome you, ma'am. Mr. R. Venkataramani is a senior advocate in Supreme Court of India and has completed 40 years of practice in Supreme Court. He was appointed as a member of Law Commission of India in 2010 and again for further term in 2013. He has also served as a member of the South Asian Task Force on Judiciary, consisting of members of SAARC nations, to submit reports on the conditions of judiciary. He also has been requested by the International Court of Justice to coordinate with its activities in the Afro-Asian region, particularly pertaining to ICESCR. I welcome you, sir. Professor Dr. V.C. Vivekanandan presently serves as a Vice Chancellor of Hidayatullah National Law University, Raipur, and has been a legal educationist for over 3 decades. He has earlier served as the founder dean of School of Law at Bennett University between 2007 to 2019. Professor Vivekanandan was also involved in policy negotiations in WIPO Geneva as a Government of India representative between 2013 to 2015 and served as a research scholar with Maastricht University Law School, Netherlands, and Institute of Intellectual Property at Tokyo in 2015. I welcome you, sir. And with this, I would like to invite Professor Dr. V.C. Vivekanandan to share with us his views on present topic. Sir.
Thank you. Thank you, Mr. Pavan. Let me first share my good evening and wishes to Honorable Justice Gyansudha Mishra here. I have heard her. Maybe I'm first time interacting with her through the virtual mode. And also to our beloved advocate, Mr. Venkataramani, who has been a source of strength for my academic activities in Bennett University, as well as with HNLU, always as obliged to be part of furthering the cause of legal education in spite of his tight schedule. And also Mr. Pavan for inviting me. So I am in a bit of a predicament with Honorable Judge as well as the senior advocate here, and there may be quite a few in the participants. My predicament, I just put it in a very small way, that this gentleman was invited to Japan to deliver a lecture, say about 25 minutes like me. Then he went there, then he realized that he speaks English, the audience only know Japanese. So there was an arrangement made that he will speak 10 minutes and then the Japanese translator will do that translation. Another 10 minutes, another 10 minutes. That was the arrangement. When he finished 10 minutes, the Japanese translator came and said only one sentence in Japanese language. But of course, the crowd was cheering, clapping. He was perplexed that how could 10 minutes of my lecture can be converted as one line in English, one line in Japanese. So the same thing happened second time, third time. All the three times it was one line. So he was quite amazed about the prowess of the Japanese language, which can turn 10 minutes of English in one sentence. Then after it's over, then there was a small get together. There was his friends, some of them knew English and Japanese. So he asked with perplexion, what happened? They said, anyway, the lecture is over. Why do you bother? No, I would like to know. Then they said, you spoke 10 minutes. The translator said he has nothing new to tell to the audience. So the audience cheered. After 10 minutes, again, he said, till now, nothing new to tell. They cheered. Third time, I already cautioned this audience, there is nothing new to tell. That's why they cheered, he said. So I am in such predicament. Only thing, you are not Japanese, all of you know English. I don't know what new thing I'm going to tell today with Honorable Judge there, who is actually the topic in a sense of activism and restraint. And then on the other side, facing the lawyer there, and both of them, what happens is something which we try to read it in textbooks to the law students inside the law school. But anyway, I said that they thought better to allow the professor to do fast, because professors sometimes are good in compiling things and putting it across to students. Then they do that. As they often say, that if you cannot act, and if you can't act, go to teach, they said. And sometimes they say, if you can't teach, go attend seminars, they say. Right? So in such way, we can't act, but we can do something about it. So I thought I'm going to give you my small presentation. My time limit was 25 minutes. I take my introduction, also part of the 25 minutes. And then I spoke a small story of the Japanese 3 minutes. So I'll try to tighten it as much as possible in this today's evening and Sunday evening, and then give my other co-participants. I just want to tell first, there could be a lot of law students here, that again, the whole question of law, which you hear in the first semester when you enter, they ask the question, what is law? And then if there are 80 students in the class, they give 80 different answers, what is law? And the teacher gives it their own answer, what is law? So then this is the kind of thing which keeps going. But anyway, we can't be without definitions. We try to capture it through some concepts. I was very much amazed by Margaret Thornton in a book called A Portia Lost in the Groves of Academic Wandering and What to Do About Legal Education. In that, she says, law is the intersection of the ideal and the real, of metaphysics and magic, of the actual and the possible, of ideas and power, of fact and value, of ease and ought, of past and the future, of the individual and the social, of economics and politics. I think this in a way summarizes in one way when we are talking about the subject of judicial activism and judicial restraint. If that is a teaching for law students, and I consider all of us in different levels are students of law continuously. So the topic what is given to me, Mr. Pavan has also little bit codified for me a few topics within the subtopics for us, so that he said there may be not much of overlap. When I spoke to Mr. Venkataramani a little while ago, he said that all subjects of law are overlap. But at least I thought I will point out few things and then possibly leave the remaining action part to be discussed by Honorable Justice as well as our senior advocate. I want to just, he gave me few bullet points. First is the jurisprudential and constitutional foundations of judicial activism. Here, I would like to say in the words of Kermit Roosevelt, who's a professor of law of University of Pennsylvania, and he elaborates in his own way, which let us see whether we agree to that. Judicial activism is an approach to the exercise of judicial review or a description of a particular judicial decision in which a judge is generally considered more willing to decide constitutional issues and to invalidate legislative or executive actions. Although debates over the proper role of the judiciary dates to the British tradition or the founding of the American Republic, the phrase judicial activism appears to have been coined by the American historian Arthur Schlesinger Jr. in a 1947 article, interestingly not in Law Journal, but one of the rich and powerful journal, what you call Fortune. Although the term is used quite frequently in describing a judicial decision or philosophy, it can cause confusion because it can bear several meanings. And even if speakers agree on which meaning is intended, they will frequently not agree on whether it correctly describes on a particular given decision. On the other hand, the term judicial restraint is a procedural or a substantive approach to the exercise of judicial review. If I say it's a judicial procedural doctrine, it is a principle of restraint which urges judges to refrain from deciding legal issues, and especially constitutional ones, unless the decision is necessary to the resolution of concrete dispute between adverse parties. On the substantive side, it urges judges considering constitutional questions to grant substantial deference to the views of the elected branches and invalidate their actions only when constitutional limits have clearly been violated. Well, as I said, I don't know whether it's a very safe play of a professor of trying to demarcate what is actually judicial activism and what is judicial restraint. Let us open up a little more and see, and then probably we'll like to hear the other two speakers throwing more light. If I look at the relationship between two concepts of judicial review and judicial activism, to start with. The judicial review has been, from American judicial history, if you look at it, it is three different sorts of power. And it also connotates in their history three different areas. I will come to later to the Indian history. The first, or the traditional period, is from the birth of the Constitution, American Constitution, until the end of 19th century. It's embraced in a notion of interpretation based on, quote unquote, fair reading of the document and a moderate form of judicial review. Because you should understand that period, it's a debate among the congressmen, not so much with the public, excited about a new nation state forming, getting independence like us from the British, of course, fought violently, and they got the independence, and they were really looking at the founding fathers there in the traditional period. They're talking about something very soft called fair reading. The second, or the traditional, or the transitional period, we call the first one traditional. The second one is a traditional period from the end of 19th century until 1937. It maintained the theory of traditional era, but at the same time, it gave birth to a more activist form of judicial review. So you are really looking at the beginning of judicial activism. Whereas the third, or the modern period from 1937 until present, it developed the new activist theories of constitutional interpretation and judicial review. So it is only in the late 30s, and we got our independence in 47. So we did definitely have a lot of theory in front of us, practice in front of us to decide what this new nation state is going to talk about the whole branch of judiciary. Of course, the mother of all democracies is UK, and you all know it doesn't have a written constitution. But again, they had a Bill of Rights. But even prior to the Bill of Rights, a commentary on judicial activism can be inferred from the famous case, Scott versus Scott in 1913, where it was observed, I quote, to remit the maintenance of constitutional rights to the region of judicial discretion is to shift the foundations of freedom from the rock to the sand. This was the commentary of judicial activism way back, almost we are talking about a century back. If I come to little more contemporary times, one of the professors quoted in some of the articles which I read is late Aaron Barak, his name. He was a professor. Also, he was a judge of the Israeli Supreme Court. He said, the task of accommodating judicial review with democratic governance is inherently problematic. Within a system of free government, the court fulfills an important, though limited role as an auxiliary precaution against both the abuse of government power by a tyrannical minority and the excesses of majoritarian democracy. This is again talking about a careful treating, but at the same time establishing why judicial activism is a must. He further observes, judicial review becomes controversial only when the court thwarts the popular will or goes too far and too fast with its construction of the Constitution. Judicial aggression in constitutional politics is lamentable and objectionable. Yet far from being antithetical, judicial review is essential to the promise and performance of free government. This I'm talking to you under the subheading given to me about the relationship between judicial review and judicial activism. Now I come to the third part of the subheading which they asked me to touch upon. That is called separation of power and judicial activism. The famous quote, power tends to corrupt and absolute power corrupts absolutely. This was made by Lord Acton in his letter to Bishop Mundale Crichton in 1887. This is the important setting for us to understand how the separation of power operates. Power connotates in a simple meaning the ability to do things. But the moot point is how such power is generated in governance, how it ought to be exercised, and the need and necessity of distributing such power, and the analysis of such power separation and overlap. It has been a discourse, not now, from Greek times. If I quote the work of Antonio Gramsci in his works, selection from the prison notebooks, which he much clearly propounds the separation of powers. I'm quoting that not continuously for our time's sake. The separation of powers is a product of the struggle between civil society and political society in a specific historical period. In other words, there takes place within the society, which another Italian philosopher, Croce, calls the perpetual conflict between the church and the state, in which the church is taken as the representing of the totality of civil society, whereas in fact, it is only an element of diminishing importance within it, and the state as representing every attempt to crystallize permanently a particular stage of development, a particular situation. In this sense, the church itself may become state, and the conflict may occur between, on the one hand, he calls secular or secularizing civil society, on the other hand, state bar church, if church identifies with the state. He goes on to elaborate unity of the state in the differentiation of powers. It is like this: Parliament is more closely linked to civil society, whereas the judiciary power is between government and the Parliament. It represents the continuity of the written law, even against the government. This is what he propounds. And he says, naturally, there are three powers or organs of political. He uses the word hegemony, which Gramsci is very famous concept. He says this hegemony is in different degrees: legislature, judiciary, and executive. It is to be noted that the lapses in the administration of justice makes an especially disastrous impression on the public. The hegemonic apparatus is more sensitive in this sector, to which arbitrary actions on the part of the police or the political may also be referred. So it's very insightful, way of expression of putting the whole thing in a matrix. Of course, Montesquieu, the French judge, remarked that there is no greater tyranny than that which is perpetuated under the shield of law and in the name of justice. Remember, this is a French judge. And also a point that power ought to serve as a check to power. It is often referred to as the one which is conceptualized the separation of powers in modern discourse. In a spirit of laws, he propounds the doctrine of separation of powers to mains checks and balances. He coined the term separation of powers, which became the guiding principles of the constitutions of modern democratic states. The model is also called as trias politica. Much before Montesquieu, little before, James Harrington wrote a book called Commonwealth of Oceania. In that, he says, there is no liberty where judicial power is not separated both from legislative and executive power. If the judicial and legislative power are not separated, power over the life and liberty of citizens would be arbitrary, because the judges would also be a legislator. If it is not separated from executive power, the judge would have the strength of an oppressor. This was much before Montesquieu, and Montesquieu picks it up from James Harrington much later. Whereas Harrington goes on to tell, miserable indeed would be the case, where the same man or the same body, where of the nobles or of the people, to exercise those three powers, that of enacting laws, that of executing the public resolutions, that of judging the crimes or differences of individuals. And he completes, all would be lost if the same man or the same body of principal men, either of nobles or of the people, exercise these three powers, that of making laws, executing resolution. Now, let us cut short the story and come down to Indian context. Let us go to the Constituent Assembly debate, where Professor K.T. Shah, a member of the Constituent Assembly, brought in an amendment called Article 40A. This article read, there shall be a complete separation of powers between the principals of the organs of the state called the legislative, executive, and the judicial. Of course, there are for and against, but let's take the views of Dr. Ambedkar, who did not agree with Professor K.T. Shah. He said there is no dispute whatsoever the executive should be separated from the judiciary. With regard to the separation of executive from the legislature, it is true that a separation does exist in the Constitution of the United States, but many Americans themselves were quite dissatisfied with the rigid separation. There is no slightest doubt in my mind and the minds of many students of political science. So the work of Parliament is so complicated, so vast, that unless and until the members of legislative receive direct guidance and initiative from the members of the executive sitting in Parliament, it'd be very difficult for members of Parliament to carry on the work of legislature. I personally, therefore, do not think that there is any very great loss that is likely to occur if we do not adopt the American method of separating the executive from the legislature. This is the setting of the agenda. Constitutional commentators are generally of the opinion that Indian Constitution does not expressly define and mention separation of powers, and yet it operates by various articles in the Constitution. For want of time, I will not get into elaboration of that. Article 53.1, Article 121, Article 122, Article 212. I'm sure that the advocate and honorable judge will be dealing. Article 361. All of this, if you read, you can see about what you want, a popular term we use, Lakshman Rekha, of each one done. But as I said, that the mythological Lakshman Rekha is, very clear, it has a different connotation. But here, the Lakshman Rekha is not so clear. And that is quite often the debate we are having, including the one today. I can only bring it to a case law in May 2007, State of Uttar Pradesh versus G.S. Bisht. Here we got two respectable honorable judges. One is late Justice Sinha, another is Justice Markandeya Kajju. Justice Sinha opines the judge-made law, according to him in this case, is now well recognized throughout the world. If one is to put the doctrine of separation of powers to such rigidity, it would not have been possible for any superior court of any country, whether developed or developing, to create new rights through interpretative process. SOP, separation of powers, in one sense, is a limit on active jurisdiction of each organ, but it has another deeper and more relevant purpose: to act as check and balance over the activities of other organs. Thereby, the active jurisdiction of the organ is not challenged. Nevertheless, there are methods of prodding to communicate the institution to its excesses and short form. Constitutional mandates set the dynamics of communication between the organs of polity. Therefore, it is suggested, do not understand separation of power as operating in vacuum. Separation of power doctrine has been reinvented in modern times. Whereas on the other side, Justice Kajju opined, under our constitution, the judiciary, the legislature, executive have their own broad spheres. It is important that these organs do not encroach on each other's proper spheres and confine themselves to their own. Otherwise, there will be a danger of reaction. He goes on to advocate. But then I have two, at least three. One, I am merging that with the next one called judicial overreach or judicial hyperjudism, and a smaller one called IPR, which has been given. Probably they thought my background is IPR. Now, when you talk overreach and judicial hyperactivism, the quote which is to be remembered is Justice Robert Jackson. He said, very interesting quote, "We are not final because we are infallible, but we are infallible because we are final." What an interesting wordplay. We are not final because we are infallible, but we are infallible because we are final. The school which wants that there is a thin line between judicial activism and judicial overreach, which has the potential of throwing the baby out of the bathwater. So there are people who caution. There is, I think in modern times, nobody stiffly opposes the concept of judicial activism, but rather they say that, how do I really remove this, keep these two? In fact, I was reading a blog by one Mr. Prakar Singh, a Delhi-based political researcher. He quotes in his article, apart from independence from politics, the judiciary also needs independence from popular interest. This is by former CJI Kapadia. Honorable Kapadia says this. This is proven true according to the author when Justice Sen of Meghalaya Court said in a ruling, political leaders were too much in a hurry to get the independence, thus creating all the problems today. That honorable judge goes on to tell, India, since it was divided on based of religion, should have been declared as a Hindu country. The author quotes this about the thin line of activism getting into overreach. He quotes another researcher, Lavanya Rajamani, who talks from Oxford, that in the Godavarman versus Union of India case, the Supreme Court defined a forest, quote unquote, in the absence of a definition in the Forest Act. And in so doing, it took over the governance of the forest in India. This is a commentary. The very first amendment of Constitution of 51 marked the beginning of a long-run battle between the executive and judiciary. And I need not tell much later what all happened, including the emergency period and what happened in Indira Gandhi versus Rajnarayan case. That I think enough PhDs have been written, so I'm not going to touch upon that. In a World Bank working paper called Public Interest Litigation in India, interestingly they say overreaching or underachieving. Varun Gowri in that report claims that the claimants from advantage class have 73% probability of winning a fundamental rights claim compared to 47% of non-advantageous class. So very interesting, even though it's not given by Mr. Pavan. Overreach and underreach is another concept. There are quite a lot of things. For want of time, I wouldn't be talking now. I might come at later. More or less, I don't really see a very big differentiation in the last few decades between the executive and the legislature happening in the country. So naturally, I'm not going to segregate and tell what is legislature, what is executive versus judicial activism. The worry we are only having is, even though there can be a lot of alignment between executive and legislature, at least judiciary remains independent. So the last part of IPR, again, I just want to touch upon for some of the IP scholars who might be attending this program or others. Very interesting. I just quote in the Delhi University, popularly known as the Delhi University photocopy case, that the chancellors, masters, and scholars of the University of Oxford versus others. The judge quoted that copyright is not a divine law, and people who are not agreeing with the judgment said this is real activism. And people who hailed the judgment, they said it is an activism which is needed. A similar case happened in competition law case with Amir Khan Productions, where the Bombay High Court held that, see, look, IPR is exclusive, but at the same time, it's not sovereign nature. It's merely a statutory right. So the courts have very clear understanding how to interpret and how to do, which was also people said it's a kind of activism. The last but not the least is the Bayer case of Nexavar, which you all know, the first compulsory license. And those who fought that case obviously hailed the court was, even though interpreting on the name of all the points before the court, they felt very happy the court is going beyond the lines of law, looking health as a fundamental right. And there is a sense of activism. So this is what the few cases which on IPR, which I wanted to quote, because we are conceptually on the higher terms. So with that, I could not keep a promise, but you will appreciate as a professor, still I am what I call as keeping my time. That is the problem with professors always. So I still keeping my time. Thank you very much. And after the other two, scholars come in, probably I might interact if I have time. Thank you, Pawan.
Thank you so much, sir. Thank you so much for explaining the topic with such sagacity and while showering the intellectual effervescence. We are so grateful. Now I would like to invite Mr. R. Venkataramani to share with us his accumulated knowledge and experience on the present topic.
Thank you, Pawan. And let me greet both the participants today. Firstly, Justice Mishra and my very dear Professor Vivekananda. I wonder whether who is talking to the Japanese audience, whether it's Professor Vivekananda or myself, right? And having known him for so long and also knowing well that he's a very profligate speaker, and I think he has given me some few foods of thought before I can hatch on to what I've been thinking on the subject. He quoted an author and a judgment, and the connection as regards law. It's between the difference between metaphysics and magic, right? And he quoted a 1940 English judgment about the movement from the rock to the sand. Right? So very important connotations flow from these two statements. Now, ever since Madbury versus Madison has been part of the landscape of law and justice throughout the world, because no part of the world today which engages in a judicial review dialogue doesn't fail to look at Madbury versus Madison. And then, but it's happened in a context when the US Supreme Court was talking about the province of the Supreme Court. So that's why when Chief Justice Marshall said that it is the province of the Department of Justice to say what the law is. So that's a very different scene 300 years ago, roughly more than 200 years ago, when a nascent federal constitutional framework was trying to understand what will be the role of the apex court of a country, and whether it will occupy the entire space of declaration of law, statements of law, and so on and so forth. So moving on from a US constitutional framework, but much later, very learned authors were talking about in Cooper versus Aaron in 1958, when the US Supreme Court was trying to enforce Brown versus Board of Education. And a lot of things happened between Madbury versus Madison and Brown versus Board of Education. Notwithstanding that famous Dred Scott case, and which Abraham Lincoln said that it could not be part of the US constitutional history at all. So why was it happening in the US constitutional framework? And then what is that people are talking in US? So a couple of years ago, when I was traveling from Long Island to New York, the cab driver engaged me in a conversation on asking me where I come from and so on and all that. When I told him I'm a senior counsel in Supreme Court, he said, I'm very interested. So I would like to tell you what is this US Supreme Court has done in Brown versus Board of Education. I just sat back in my chair and said, this cab driver is so well informed about racial segregation and what US Supreme Court has said about the ills of racial segregation and the struggles with the judiciary had to grapple with ensuring that racial segregation does not continue as part of the legal and judicial landscape. I was really interested. I was wondering whether if that happens in our country, if I had to engage in a daily conversation with taxi drivers or auto drivers or any common men in our country, I would ask me, sir, what's the Supreme Court done in saying I have a right to environment, I have a right to clean air, I have a right to have a road, I have a right to have this. I know a whole range of rights the Supreme Court has written into Article 21. Imagine what kind of a social and political environment our country would be in. It's a very interesting question to ask, because when everybody is talking about the encroachments of judicial institution into the spheres or the other two, establishments, mostly. And who is talking about it? And apart from law schools and law students and lawyers, who is really talking about it? The people who are really talking about today are perhaps parliamentarians and those in governmental power. And why are they worried about it? Why are they concerned about it? And what is that the court is doing to aid them on to say engage in good governance? So therefore, when we really look deeply into the question of judicial activism and judicial restraint, we have to ask some very important questions, because a lot of conceptual confusions seem to have taken place. Is one thing to say in a constitutional framework within the definitions or the delineations of statements within the Constitution as to what will be the scope and province of the judicial department, and whenever it crosses or extends beyond the domains carved out within the Constitution, then one can understand a question whether it's a case of judicial overreach or breaching the frontiers, so on and so forth. But once there is a Constitution which says that you have to enforce rights, the obligation to enforce rights, that transform constitutional values and principles into reality, then on whom does all these obligations rest? Does it rest exclusively on the Parliament, the executive, or to go back to the question as to whether the right or the authority to declare what the law is ultimately on the Department of Justice? But then the question arises, what do you mean by declaration of law? I think long ago, many English judges were talking about the myth that has to be busted as to whether the judges only declare law and do not make law. So, but that bust has been busted in an English administrative law situation, where England, with all the unwritten constitution, has still been talking about the protection of rights of citizens. The Englishman is the king in his own castle. And for what reason? Not because they had a written constitution, but because within the limits of the law, as every statute provides for, every statutory authority will have to abide by the principles and reason of law. But the question arose, when you try to interpret a law, and all those judgments which quote as part of interpretative exercises, ironing out the creases we talk about. So who does the ironing out the creases? Why do we need to iron out a crease? So why there is a crease at all? So when you talk about this crease in the Lakshman Rekha, I think we have to understand a distinction between a country which is ruled entirely by an unwritten constitution and countries which have written constitutions which clearly delineate the tasks of each establishment or institution under the constitution. But then that is not as simple as that. Now, the declaration of law, when you are talking about a mere statute, is a very simple task. You can say whether a telegraph would include in contemporary time the telephone is a very simple issue. But you talk about whether a right to life would include a right to live with dignity, it's not as simple as that. Therefore, even in the human rights dialogue, when we earlier talking about the division between civil, political, and rights and social, economic, and cultural rights, there was at some point of view that there is two distinct concepts. The two rights operate in distinct realms. But by and large, as we moved around in global history and following the collapse of Soviet Russia and the East European countries' socialism, we have now understand that all human rights constitute one compact principle. You can't divide social and political rights, civil, economic, and cultural rights into distinct components. And what is that reason? Because you're talking about constitutional frameworks, constitutionally guaranteed rights. The question is, how do we really understand rights, give meaning to those rights, and ensure that enforcement takes place in accordance with those meanings, which only a court of justice would probably be called upon to do. That does not mean that the parliament and executive does not have the authority to give their own meaning. But the question is, who will have the final say on what meaning a particular proposition of law or a provision of the constitution will have? Therefore, when we talk about judicial activism, let us keep it very clear in our mind. What has happened in US constitutional history about what is the province of the Supreme Court of the United States to say on whether abortion rights or to say racial segregation and all those issues, whether the province assigned to the Supreme Court of US is being breached by interpretative processes. So within the constitutional framework, US Constitution does not have a Bill of Rights. It does not have social, economic, and cultural rights. So it has a very skeletal constitution, but where, like the 4th Amendment and the 14th Amendment, I'll just read what's happened. Somebody wrote a book on Royal Berger, wrote a book on titled Government by Judiciary. The huge book was about the 14th Amendment exercised by the US Supreme Court. And let me just quote what he says in his introduction, and it makes important, very interesting reading. He says, a quote, "The 14th Amendment is a case study par excellence of what Justice Harlan described as the Supreme Court's exercise of the amending power. Its continuing revision of the Constitution under the guise of interpretation. Because the amendment is probably the largest source of the court's business and furnishes the chief fulcrum for its control of controversial policies. The question whether such control is authorized by the Constitution is of great practical importance." I'll quote a bit little more, but before I do that. And why is that in US constitutional framework and US constitutional history, people are talking about the breaches by the US Supreme Court? It's one thing to say that you don't have a power to interpret beyond what the original intent of the Constitution thought about. That's a different debate altogether. In fact, by and large, the debate on judicial activism in US has largely hinged on the original intent versus the interpretative exercise undertaken by various judges. But we're not talking about the original intent of the Constitution. Let's say, and then there are authors who have written about what do you mean by original intent? So if there are 100 people who sat in the Constitutional Assembly and did they all one common intent? These questions are asked in classroom discourses. We do not go into all that exercise at all. So therefore, if the Constitution as a written document comes before us in black and white, and if a Constitution says you will have a following rights, then the question is, how do you really ensure that the rights are practiced by the civil society, the rights are enforced by the executive government, the rights are properly understood by the parliament to ensure that the rights have a certain legal statutory proposition which ensure their enforcement. And this is not a very simple task again. And therefore, in a country like India, and as compared to a country like England or United States, we have a different or entirely distinct constitutional dialogues and debates. Now, having said that, if you the Indian Constitution of 2020 is certainly not the Constitution of 1950. If the framers of the Constitution were to look at today at what the Constitution is, they'll probably sit back in their chairs with a lot amount of surprise. Not because the letter of the Constitution has been changed, but because the meanings and grafted in the Constitution were widely and vastly different from what the Constitution makers thought about. And that, therefore, is what a professor was talking about, the distinction between metaphysics and magic. So sometime between 1950 and 2020, a lot of magic has happened in the Indian constitutional scene. And why do you call it a magic? It's because if metaphysics is also a realm beyond, rational thinking, magic is also beyond rational thinking, but in different ways. Metaphysics at least a part of a discursive process, but magic is something which is beyond our rational thinking. But why do you call that 1950 to 2020 is a magical exercise? Because we have moved, as in the late 70s, Justice Krishna and I were talking about, every judge is an activist either in the forward and the reverse gear. So we're talking about the forward gear and the reverse gear. And then post-emergency, we're looking at the country from entirely different angles. We did not have, for instance, fortunately for us, like a totalitarian history stretching back for 50 years as what happened in a Soviet Russia or some other European countries. Fortunately for us, the totalitarian period or the dictatorial period was very short, but we learned very important lessons. And those important lessons have probably steeped very deeply into the social and judicial psyche in our country. And the judicial psyche has captured the important moments for a social and judicial transformation. And how is that possible? Is it possible through parliamentary democracy alone? Is it possible only through social struggles? Is it possible only through people's participation in public, demand for public accountability for government? I think all of that is part of a social transformation exercise, including the participation of the courts in our country to transform the meanings and understandings of the Constitution. Therefore, in any country where the final court has a say in delineating meanings of the words of the Constitution, that final say will necessarily be part of a transformation process. So if you don't have a transformation process, we are stuck in history. We are fossilized. And therefore, when you're talking about judicial activism, let us not use it in a pejorative sense. I'll immediately come to what is happening in the context of what people call the overreach. I'm very conscious of what's happening in contemporary times. Probably a practicing lawyer, I'd probably say that many things which are happening in the Supreme Court of India are to be seriously questioned, whether it's by people who are coming to the court, whether the court accepting petitions, or the court without strict scrutiny of the choices to be made at the threshold, the justiciability of the issues, etc. There are very serious and important questions to be debated. I think not only in forums like this, but beyond these intellectual forums. But it's important for us to understand that when you're talking about judicial activism, let's understand something very, very clearly. When you're talking about a constitutional framework, something happens. When you're talking about a non-constitutional framework, something else happens. So within the constitutional framework, definitely there is a role notwithstanding Montesquieu's principles, which are done in an entirely different historical context. Professor Vivekananda briefly talked about it. Harrington preceded Montesquieu, and Montesquieu came at a time in French the French Revolution, at a period of time when all power vested in one hand. Therefore, the question was not today whether all power is vested in one hand or not. We have moved far, far away from Montesquieu. So once having moved away from Montesquieu, the question is, do we rewrite Montesquieu within each specific constitutional framework? Therefore, the question about judicial activism, judicial restraint will have to be seen from this context. And briefly talking about judicial restraint, again going back to the US constitutional history. And there, if you voted in favor, if the court voted in favor of the New Deal policies, well, it is judicial restraint in favor of what the Congress wanted to do. If you voted against it, then it is judicial activism. If it all depends on whether let us look at a case like Lochner versus New York. The minimum wages, etc. The issue, Lochner was a big issue in US constitution in the New Deal era. So if Lochner had been decided differently, and why did US Supreme Court decide Lochner in that way? The importance of enforcing contracts, freedom of contracts, like the English judges were always keen to enforce contracts because contracts is a fulcrum of a free market economy, a capitalist economy. Therefore, contracts must be enforced. Whether it's going to injure somebody's labor rights or not does not matter. So Lochner took that view. So give a comparison like in our country, if the Minimum Wages Act, suppose, had been struck down in our country, the Lochner way, and then we would have said, well, yes, here is a Supreme Court which is not activist. It has exercised judicial restraint in favor of the freedom of contract. But then the Minimum Wages Act was an important milestone in our country. The equal remuneration legislation. Look at the whole range of legislation from 1970 to the late 80s. You look at all of them. They are all a brand of welfare legislation, trying to advance each and every principle of Part 4 and then the obligations and in Part 4 of the Constitution. Therefore, if all these welfare legislations have been struck down by the Indian Supreme Court, as the Supreme Court did in the early 50s, when the Zamindari and land reform laws were struck down before the First Amendment and soon after that. Now look at the contrast. If the First Amendment has not have been occasion, but for the Indian Supreme Court saying Zamindari did land reform laws were unconstitutional, Article 31, etc., would not have come into picture at all. Then somebody would have said, well, the Indian Supreme Court is, has exercised, activism or judicial restraint either way. So therefore, what has happened in our country may not be strictly compared with what's happening in the US constitutional history. The judicial activism restraint in the US constitutional debate is of an entirely different background, dimension, and historical aspect as compared to what's happening in a country like India. Just give a few examples in Asia. Now, after the collapse of Soviet Russia, virtually almost the entire European continent has been writing constitutions, rewriting them, amending them. And if you look at some of the constitutions of the East European countries, a small country like Herzegovina, they have an entire chapter on human rights. Like what happened in the 1993 Human Rights Act in England. So prior to that, England would not have talked about compatibility of human rights and the rights of citizens vis-a-vis in a supranational constitutional framework. But in 1993, when the Human Rights Act came in England, the compatibility of English law vis-a-vis the European Convention became prominent. In English court, it could have said an English law is now not compatible with the European Convention. But fortunately, after Brexit, that question does not remain. So after 1993-98, the Human Rights Act in England and a country like Herzegovina, with a constitutional framework entrenching human rights and fundamental rights, question arises: should a court called upon to give a meaning to a provision of the Constitution, should it be active in the sense, give the proper meaning, or should it be restraining in the sense, should it sit back in the chair and say, I leave it to the meaning of the parliamentarians or the executive? So which one would be a judicial activism or restraint? So what restraint would be appropriate? Therefore, we are talking about an onward movement of a constitutional framework, having regard to what people all over the world, in different parts of the world, notwithstanding different historical backgrounds, now have or wedded to one important thing, namely the idea of a constitution. The idea of a constitution is something which is now an impregnable part of the human psyche all over the world, regardless of differences in the constitutional framework. That does not matter at all. So therefore, one fundamental thing we are talking about is, please do not let us confuse what's happening or then transpose what's happening in US constitutional history into what may happen in different parts of the world. Debates are entirely different dimensions. Now, having said that, Pavan wanted to talk about Professor quoted about a 1940 judgment from the rock to the sand. I think that's a very important statement to pick up. And how do you pick up this statement? If you think that the parliamentary enacted law and the executive determination of law is like a rock, because you know what it is, it's all certain. Everything is certain about the law. But we leave it entirely in the hands of the court, it becomes sand. So everything is uncertain. So today there can be a precedent, tomorrow it can be overruled. So we see that happening in every jurisdiction. So when whether the US Supreme Court or the House of Lords or the Indian Supreme Court saying that we are certainly not bound by our precedents, and in circumstances where a particular precedent would be probably in frustration of the onward movement of law. We could have done a very important study of how overruling of precedents by the Indian Supreme Court whether in terms of impact of economic analysis or social impact analysis. Nobody has undertaken the study. But we do see that there are overruling of precedents sometimes frequently, sometimes hesitatingly, and sometimes for reasons which are very clear. Unication was overruled. Unication was a landmark judgment talking about the need to regulate education in the hands of capitation fee phenomena. Unication was overruled because a later benches thought that we need to free unication and free regulation, and then so that the free movement of education should be in the hands of an only unregulated enterprise by educationists. So therefore, it all depends on whether we're talking about which kind of regulation you want to shift from. So we have the Balco case or the Narmada Bachao Andolan case. So all these cases, what do they mean? They defer to executive wisdom merely because the judges believe that executive wisdom is important, or because the judges had a personal philosophy of their own where they thought a pre-market enterprise is more preferable than a socially regulated or a socialist form of government. So it all depends again. All of us know that famous book written by the English writer John Griffiths, the Politics of Judiciary. So when he wrote it in 1970, it was a great controversial contribution to the how judges got appointed in the higher courts in England, and how their politics and their political ideologies virtually shaped everything in the judicial landscape of England. So if you look at a contribution like that in India today, somebody were to write, and I'm just remembering, at least in US, people can write about all the US 9 Supreme Court judges as 9 scorpions in a bottle. If I have to use such terms today, probably I would be very scary of contempt of court. But that's a kind of freedom of expression available. So therefore, it's important today to move away from sterile debates on judicial activism versus judicial restraint, and to move into a different set of institutional restructuring where accountabilities, transparency will become the mantras of, constitutions functioning, real function. And then if that happens, you will probably understand the difference between metaphysics and magic, and so that it's what is rock is really not rock, and what is sand is not really sand. So rock can become sand and sand become rock. Therefore, as long as we don't do that, we will be always talking about very rhetorical debates on judicial activism. And that's what I thought we must look at. Now, Pavan had asked me to also talk about the movement from formalism to realism. I briefly mentioned about the post-emergency period. So if you look at the post-emergency period and look at the large number of cases that came before that, whether land ceiling legislations or the women's equal rights legislations, the Pathuma case was that by Supreme Court, and you look at the whole range of legislations and the issues adjudicated by the Supreme Court. Now, I'm not talking about cases where somebody petitioned from jail reforms or child rights issues. I'll soon come to the environment, dimension. So the cases where challenge to the legislative exercise, legislative wisdom of Parliament, and where Supreme Court deferred to the legislative wisdom because they were welfare legislation, the different issue altogether. But cases where the Supreme Court began to receive petitions and also entertain adjudications which were otherwise thought to be non-justiciable, they mark a different shift altogether. So if you look at those categories of cases, which were the foundations for the Supreme Court engaging itself in the transformative dimension of the Indian Constitution, then we probably, at some point of time, in some manner, talk about judicial restraint. And that will make an important contribution. Therefore, it's one important thing to find out from the 1980s, where the choices of issues to be undertaken for adjudication by the court, the manner and method of receiving those choices, the procedure to be adopted for receiving those choices and rendering them justiciable. So if you look at all of them, that's the moment when the Supreme Court converted them from a formal judicial institution into a real transformative judicial institution. Therefore, you look at those categories of cases, you find the Supreme Court's contribution today. And for instance, again, if you look at countries like in Colombia and South America, or I give two instances in the Korean Supreme Court or the Indonesian Supreme Court, you can multiply examples all over the world. The Korean Supreme Court was talking about certain provisions of the Constitution, which I said following Professor Lawrence Tribe, the invisible part of a Constitution. So Lawrence Tribe is famous for making a statement about the invisible part of a Constitution, which probably contributes to the making of the Constitution. The Korean Constitution, the Korean Constitutional Court talked about three important cases where it drew inspiration from a mere preamble to the Constitution. The Indonesian Constitutional Court draw into Article 1.3 of the Indonesian Constitution, which talks about rule of law, which is probably described there as negara hukum, rule of law. So the Indonesian Constitutional Court said this rule of law means what? It means access to justice. It means fair trial. It means freedom of expression. So it began to read into rule of law and negara hukum what all the Indian Supreme Court does into Article 21. So can somebody say, how do we really explain these superior constitutional codes all over the world, trying to locate the source of the authority for saying what they think they are competent to say? So do they say it in every constitution that with some chapter says judicial review means the following? I don't think that will ever happen. The moment you say judicial review will mean the following, you are going to straitjacket and confine judicial review. And that what did not happen in the US constitutional history. No part of the US Constitution says judicial review is definable. In the very nature of a social transformation, in the very nature of an open society, in the very nature of an open society where all freedom must flourish, not under any particular dictations of ideology, but in an open participatory process. In the very nature of all this, probably it is important that constitutions do not define limits of each institution, but lays on broad contours. Of course, all of us know that no superior court in the world has ever done primary legislative work. And the Indian Supreme Court certainly has not done that. The primary legislative will be always done by legislature. But the question is, after a primary, the law has come to the legislative mint. How will the law work? And if the legislative mint is silent, how will the society work? if the executive mint is silent, how will citizens expect and ensure that their aspirations and their legitimate expectations really get transformed into reality? So these are not answered by mere constitutional delineations of power and authority. They're answered only by the functioning of the respective institutions on an understanding that I move the line a little here, I'm going to do a little wrong. I move the line a little here, probably I'm wrong on the other side. Therefore, judges do really understand. Courts also understand moving the line too much and too far, or not moving a line at all, is always about separation of powers. So there's nothing, therefore, once that we understand the magic, we also cross the metaphysical realm. So today the question is how to really understand the magic and then convert it into certain principles which are followed as far as possible. And you're going to talk about only about following these principles. Now I must also address, as I said, in contemporary times, if there are all kinds of challenges that are coming to the Indian Supreme Court. Because COVID-19 has been an excellent example. And because Parliament is not there, the central government could not answer all the issues. Supreme Court became the overarching, governing institution in the country. We have seen all kinds of claims and issues being brought before the Supreme Court. If somebody were to do an analysis of these issues and find out why they are being brought before the court, and in a certain circumstance where probably all other legal social avenues are either circumscribed or limited or perhaps not open at all. Therefore, imagine that if a COVID-19 situation were to continue forever, I'm just giving an example, just imagine that. If this has to continue forever, and if we don't have a parliament functioning, and if we don't have a central government or governments functioning because of a serious set of limitations, then what is the role of a constitution? And how do you really ensure that a constitution becomes alive and does not become a dead letter? Once you put yourself in the framework, then probably we'll find out how we can give an answer to this question when we are in free and open times, when we don't have a COVID-19 situation. I just want to give that illustration to fix our frame of mind, but to understand that if we are talking about certain doctrines in a different situation, we will have to clarify to ourselves the doctrines in entirely different situations. And but having said that, the distinction between what's called activism in interpretation and fault finding with legislations and minute engagement by courts in every aspect of governance, this distinction has to be kept in mind. I'll give you an example. Recently, what happened in the Andhra Pradesh High Court. The Andhra Pradesh government wanted to paint the panchayat buildings and government buildings in the rural areas, and then it thought that it has the tricolor of the party in power. It wanted to somehow bring in the three colors as part of the the color scheme for painting the buildings. So somebody goes to the High Court and says, look here, the color chosen for painting the panchayat buildings reflects the flag of the party in power. Therefore, it is an abuse of power, it is arbitrary. The High Court allows that writ petition. High Court enters into a detailed discussion as to what should be done regarding painting of buildings or the panchayat building for the government. I do not know, in such circumstances, apart from the question of a propriety of what a government may or may not do, or promoting its own party in power, the propriety of it being entirely a democratic process, are these matters for the court to enter into and find out whether it is arbitrary, whimsical, or an abuse of power, so on and so forth. Therefore, these are those test cases where courts enter into what I call the domains where the democratic process must be alive, democratic process must flourish, and it is not certainly the province of the court. You can give any number of examples in recent times. So therefore, if that is the position, how we understand judicial activism and judicial restraint, and I find Pavan also asked me to talk about public interest litigation, having authored a book at the instance of the Judicial Committee on Restatement of Law. Only one thing comes to my mind, that all of us know that in early part, Justice Mishra has seen the Indian Supreme Court in the early 80s when we were rubbing shoulders before very erudite judges. If somebody had not written a letter from Tihar jail, or somebody had not brought to the notice of the Supreme Court, look what's happening in Bihar in a particular circumstance. If somebody had not brought to the notice of the court as to what's happening in sand digging in rivers which undermine the environment, then probably, let me tell you today, notwithstanding all those developments in public interest litigation, governmental abuse, we still hear about, sand mining mafia in our country. We still hear about all kinds of mafias in different parts of the country. Now, are they being controlled by a judicial overreach or judicial activism or judicial restraint? So how do we relate to all these issues? Therefore, the question as to whether how do we really articulate principles, how do you structure them, how do you ensure that there is, once we structure them, that there is no transgression of the structures. So these are important discussions. Till today, in the realm of public interest litigation, we have not really entered into these debates. We have only been talking about limitations, abuse, so on and so forth. We have probably not really ensured that each court, if they have to be monitors of their own jurisdictions, how does each court structures its procedure? How does each court ensure that I will not enter into a question which should not be just seen as justiciable at all, which should not be adjudicated at all? Professor Vivekananda mentioned about the Godavarman case. Now, what happened in the Godavarman case? What has happened today? The entire forest issue being taken over by the Supreme Court through its empowerment committee, so on and so forth, is a virtual institutional process entered into by the Supreme Court. So what could have ordinarily been done by the executive government has been done by the Supreme Court. The Supreme Court set up an institution, Supreme Court monitors it, Supreme Court lays on principles, Supreme Court lays on practices. So virtually taking over the domain of the executive government. I ask myself a question, has it contributed to a wrong? Has it contributed to a malady which could have been probably corrected by a legislation? Why is that? The parliament has not so far said overriding law on Godavarman. Why is that no state government has been able to frame, either enact a law or executive instructions on how do you handle our forest resources? How do we ensure that notwithstanding the environmental laws in our country, we still have a problems of environmental degradation? And then, so we have all those questions. And people again, criticize the Supreme Court of India in the recent, liquor ban case on highways. There are examples and examples one can multiply where the Supreme Court probably had strayed into domains which probably it need not have. There are very clear cases. And look at all those new cases coming to the court where every, you remember when Jagdembal Pal's case came, people are criticizing why the Supreme Court entered into this matter. But the parliamentarian, the legislations came to Supreme Court. Supreme Court did not do any suo motu action. You invited Supreme Court to resolve your problem, your legislative, parliamentary problem. So today, every state government, every reorganization of within the legislature, everything which happens in legislature is about change of guards. People bring it to the Supreme Court. Why? If Bombay has not been declared by Supreme Court, probably position would have been different. In state of Rajasthan in 1978, Supreme Court said these are political questions. We will not touch them. But Bombay said no, these are not political questions. They are justiciable by the Supreme Court. So once you open up a gate, and then I don't think you can stop that gate from the sluices which will keep on bringing fresh water into this gate. And that's what's happening into those very sensitive, politically sensitive issues, which probably, in my opinion, court will have to place some restraint. I don't think the democratic process will be curtailed if the Supreme Court would say, sorry, we will not enter into the dialogue at all. But then today we can't say that, as some people say, because our legislature will have to function. Somebody will have to find out which legislature will function. Therefore, who can find a solution? So these are questions which do not have textbook doctrinaire answers. These are questions where no constitutional textbook can say this is right and this is wrong. Therefore, all that one can see is, except in those fringe, in a line of cases where Supreme Court ought not to enter into, because you are actually investing your judicial resource into matters which must necessarily belong to the democratic process. Unless, otherwise what happens, the democratic process, the weakening of the democratic process is the event. Therefore, we must be very careful about the weakening of the democratic process on the one hand, and the strengthening of the democratic process on the other hand. So can we look at judicial activism as strengthening the democratic process, as strengthening governance, or do we look at judicial activism as weakening democratic process? So let us open up all those kinds of dialogues and debates. I think therefore, I would probably just conclude with that, except saying that watching the Supreme Court for over 40 years and looking at what's happened in the rest of the world, I think, and if constitutional law textbooks elsewhere, whether in US or in Europe or in a European context, are looking at what the Indian Supreme Court has done in transforming constitutional meanings and giving constitutional provisions meanings which they must receive and ought to receive, then I say the Supreme Court of India has really contributed to an open Indian society flourishing. The Indian society is an open society today, and it's an open society for a variety of reasons. And if you think that we need to have an open society, we need to have an institution of, the final institution, which must also have certain open frontiers. And if you don't have the open frontiers, and I may say the lock must ultimately, the key for the lock must ultimately lie with the judges and with the institution. I don't think the key can lie elsewhere. And that's my say on judicial activism. Thank you for the attention. And I think, I hope I've not spoken to a Japanese audience.
Thank you so much. Thank you so much, sir, for scanning the anatomy of the existing problem lies in these concepts, and also explaining the background of judicial activism restraint in USA and India, and projecting the how they're different from each other, and making us understand, stating the real meaning and difference between metaphysics and magic and its relation with judicial activism and restraint. It's a beautiful observation. Now, I would like to invite a chief guest, Honorable Mrs. Justice Gyansudha Mishra, to share her thoughts with us. Justice Mishra.
Hello, the great anchor, Mr. Pawan. Nice to see you after hearing you on just the audio medium.
Thank you.
It was a pleasure listening to the eminent speakers, and although Professor Vivekananda said that the order of putting the speakers in order, perhaps he had his own reactions, but I think it is extremely appropriate that an eminent professor has started, and a very able and eminent senior advocate has discussed the subject, and finally the judge's perception has been through.
Give me your phone. Give me the phone and give me the.
Very carefully listening to Mr. Venkataramani, and initially I thought in a professor exploring and expanding the theoretical aspects, but a lawyer is a lawyer, and ultimately he has jumped to the point, the judicial activism, but he has done it with so much balance. Then I think as a final panelist, I guess I would have to be a little forthright insofar as this topic of judicial activism and judicial realism is concerned. Fortunately, because behind the screen inputs, I would like to share that some of the queries and the questions that were that the anchor would want the audience to know. I wouldn't say conservative, but a very disciplined way of implementing the constitution was within the domain of the courts. The Supreme Court was traditional in the sense that it was doing exactly as per the letter of the law. But I would say that those were the times when the governance was, after the independence, was at a nascent stage. And therefore, and the mindset also, I guess, of our predecessors have been to be very traditional. So in that sense, when the constitutional precepts, the constitutional provisions were implemented, there were not, we were not at all concerned about the judicial restraint and judicial activism. But slowly, you know, when the historical events came into existence, and the issues one after the other started coming up, then the courts started becoming radical. Like, first of all, it was zamindari abolition, then it was the abolition of privy purses, then it was nationalization of bank, then the governance also started taking measures of reform, which the people were endorsing and people were not endorsing. In both ways it came. And therefore, the courts were compelled to deal with those aspects and come out with a judgment what is in the best interest of the masses. So far, so good. Then we came into the, till then also, I guess, the word judicial activism and judicial restraint was not at all for anyone to feel concerned, because all of us knew, because all of us, it's a body of experts. So it's not that the separation of power within the judges, you know, considering that we have to maintain the theory of separation of powers. So in the past, when the traditional school of thought was there, this laws, when it was enacted in the 50s and 60s, and while land reforms, like, you know, giving rights to the girl child, the women being given equal rights in the joint family property, it's not that it was endorsed by all. I remember one of my colleagues saying, अरे ये this happened, you know, इन्होंने तो घर घर में झगड़े करा दिए. Every family is having, you know, disputes. So what I'm trying to put across is that if the why does the, you know, this momentum of judicial activism started seeping into the courts? Obviously, when the enactment or a law or constitutional validity is brought before a judge, he or she will not remain a silent spectator to what is brought before. And obviously, the personal approach, the school of thought, the philosophy which the judge, you know, follows, obviously has an impact on it. And therefore, the judgment started coming in like, you know, a majority judgment, minority judgment, then again a larger bench, and then after constitution bench. It cannot be avoided. So in that sense, we cannot really, because I have to be a little, as I said, the separation of powers has been laid down, I mean, on the basis of which the entire governance proceeds. But at the same time, we have to think, why does this judicial activism, and obviously judicial activism comes in initially within the domain of the courts, because when the matter is brought before the Supreme Court to test the constitutional validity of a particular act, then that would not come, in my opinion, and I think majority of you will agree, that that doesn't give rise to judicial activism. Of course, the personal philosophy, personal approach of a judge would govern and would be tested with the anvil of the constitutional precepts. But that slowly, that that reforms was kick-started by the legislature and the executive, which started coming into the domain of the court. As I already said, it is so far so good, no problem. Now, where does it get ignited? Because you see, when we are sometimes it's I don't know, I'm slightly missing that. Is it judicial restraint versus judicial activism, or it is judicial activism and judicial restraint? I don't know, Pawan, how you have coined it. But if it is, the moment you say it is judicial activism versus judicial restraint, obviously an element of friction gets reflected from the very subject. And it is, it's not, I think, we can't afford, as I said, that we'll have to cover up and will not test that subject in a slightly point blank manner. So the judicial activism then entered into the court, in the proceedings of the Supreme Court. First of all, in my view, it started seeping in from the 1970s, and through a public interest litigation, even a letter petition was entertained, and that school of thought, which had a traditional mindset, thought, how come a letter can be entertained as a petition? This is something very shocking. And to just quickly to say something on this, the letter was treated. Then the question of locus standi came in. Then the question of different permutations and combinations of judicial activism started coming in. So, suo motu proceedings. Now, suo motu proceedings was slightly common in the High Court, but in Supreme Court it was not suo motu very rampant. At least in Supreme Court, I as a sitting judge of the Supreme Court have never taken suo motu proceeding. But the question is, and I quite appreciate that the concern is bound to for all of us to deliberate, to have a healthy discussion, to see that to what extent this should be acceptable, and a public opinion should be encouraged to accept such a situation, or not to accept such far-reaching consequential methods, which may not be quite in tune and within the ambit and concept, the ambit of of the constitutional framework. Because as you all know, we all know, there is no word as constitutional motto has been defined very extensively anywhere. It's the experience which is teaching us, but then we have to see the wisdom behind it and whether to accept it. But once I remember in Delhi Law Faculty, one young student as a fresher LLB graduate, he puts me a question, ma'am, what are your views, point blank, what are your views on public interest litigation? And my instant answer was that, you see, it reminds me of a theory of physics, which they say is water seeks its own level. My view may be, I may support PIL, I may not support PIL, but water seeks its own level. So if there is any, I would like to, pick up a thread from that answer, that whether you like it or you don't like it, but if a situation pains the people, if it pains the masses, that pain is going to come out from somewhere, either in the form of a PIL or in the form of a judge's own conscience by taking so motu proceedings, and even the legislature to address it. Like you say in this Nirbhaya rape, this minority of an accused, it's all a consensus. There was the parliament cooperated, the masses compelled, the judiciary as also the judiciary, in the sense that it upheld it. So all these, what I am trying to convey this, that when you say judicial activism versus judicial restraint, it is not a versus, according to me. We are all striving to reach at a stage where there should not be a collision course, but it is the cohesive course. We are all trying to reach at the just cause and the just conclusion. And the bottom line is that whether it is through a legislature, whether it is through the courts, whether it is through the PIL, if it has truth, truth has got its own force. It is bound to be interfered, it's bound to carry weight, and it's bound to compel the parliament or the legislature to ultimately give a shape to the enactment. Talking to this august audience, one after the other, examples are coming in my mind. Long ago, as Justice Jus Dare would call me a baby judge at that time. So as a baby judge, when I had attended a conference on domestic violence, although I had attended, it was in Kathmandu, I think it was the UNICEF which had done it, but I had a negativity in my mind. Like what good will it, serve to we have just come here, we'll have a gala time, we'll eat, drink, make merry, and then go and forget everything. But time taught me, experience, no, it was not. After that conference, and then, then finally Domestic Violence Act came into being. In fact, I would not, in a lighter vein, I would say, I was invited to a university, and the professor came to invite me. I was a sitting judge of a high court at that time. And then and I appreciated, though it's a very good talk. I don't right now remember exactly the topic, but I was very delighted that, it's good that the university also is involving, is kick-starting these subjects. So the professor was very happy. Ma'am, I'm so happy that you are appreciating it. Otherwise, so and so, I wouldn't name the politician. He says, कि पता नहीं ये निठल्ली औरतें क्या क्या करती रहती है. This was that I'm quoting, ये निठल्ली औरतें क्या क्या करती है. So there's a mindset that if you do something, people think that you have nothing else to do. You just want to while away your time in doing something or the other. But unless you deliberate, unless you discuss, unless you see the pros and cons of a particular situation, it will not reach you to the right conclusion. So also that, of course, that's not that what I said was, that was in context of when you are discussing judicial activism and judicial restraint. And Pawan, you had something like a question answer this thing. You said something. Yes. Whether there is a requirement of judicial restraint. This is also one of your queries, and I won't say question. It's your concern to know. Restraint, I see no one can teach anyone a restraint, and much less constitutional authority who has got all the authority to legislate. But the judges are by training, by their experience, by seeing the reactions, there's an automatic restraint in every judge. That's my perception. That the judges would know where to stop, would know where to stop. And I would like to Pawan, let me know when I have to stop, because I thought, what will I say? And suddenly you realize that, oh, you don't, I mean, when are you going to stop? So please tell me when I have to stop. Please remind me about that. I'm not
sure.
So I remember when you talk of restraint, I'm reminded of that case of euthanasia. With the right to for the younger audience, euthanasia. Of course, everybody knows it by now. The right to die of a terminally ill patient. And I don't know. I hope I would not provoke my ex-colleague Justice Karju when I'm sharing this, because when that petition, maybe it was a PIL only, and that came up before us. On day one, he said, we are going to allow this. I said, you're going to allow this, but we have never heard it. And because these days, like how society has degenerated also, somebody might want to do away with a terminally ill patient for so many reasons. And then I floated the question in the open court to one of the eminent lawyers, that please, when we address it, when we assemble on the next occasion, please address us also on the question of locus standi, because my senior colleague says that it's like it should be allowed. But even if you were to allow it, the question would crop up: who is going to take that initiative? Who should be permitted? And I gave an example. Then we had behind the screen, we had a very fiery discussion, myself and Justice Karju. I don't think there's any harm in now sharing it, because now the story is over, and we have the best of exchange of thoughts and ideas when we were together. So, and he said, what are you talking of locus standi? Do you know that I can give you half a dozen judgments on locus standi? But at times the fire in me also, doesn't die down. I said, brother dear, मैंने भी 16 साल घास नहीं छीले हैं. I know how many judgments are there on locus standi. Locus standi is a theory, but locus standi for a public cause by a public spirited person is one thing. But euthanasia, applying euthanasia, is something different. Like, even if we decide, then who is going to do it? So and now I won't go beyond that. What I'm trying to say is that that restraint to one of the brother judges who thought that on day one the euthanasia would be allowed, and I was on the other end, like he was on the North Pole and I was on South Pole. I felt, if we allow, tomorrow somebody might be killed, and mere ko to jeev hatya lagegi. So I was, very upset. And I even remember sharing my, agony to some of my colleagues. Ki aisa aisa ho raha hai. Then they said, ki, why didn't you ask the Chief Justice to change the bench? I said, no, that I will never do. But so finally, we had a very, 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 like balanced, like I moved a few steps forward and he moved a few steps backward. And that's how we said passive euthanasia was accepted, and there were some checks and balances how to do it. So restraint ultimately comes before the judges considering the issue. And ultimately every judge is a judge within his conscience who would come how to exactly go about it. But the judge's problem also is that you may write the best of judgments, you may write the most lucid and most knowledgeable and valuable and very beneficial judgment, but ultimately it can only satisfy the majority. It can never satisfy each and every individual. It can never satisfy each and every individual. You may write any judgment, there are bound to be opinions, but if it is, majority is granted, if the large masses accept it, then it's treated as a good judgment, acceptable judgment. So we should not be overtly concerned, what will happen if there is no judicial restraint, what will happen. A judge would not like to make himself a laughing stock. So he will definitely care that whatever is for the, and what I say is that if there is force in the cause, if there is substance in the cause, to baat niklegi to dur talak jayegi, and truth will have its own force. If the cause is right, if the remedy has been given by the court, which is right, it is bound to be acceptable. So first of all, I try to crystallize what I'm trying to put across is that although there is a concern, and quite a growing concern, as I said, 10 years ago also this topic was discussed. Today also we are discussing this. Then obviously it's a matter of concern. But concern, I don't think, it should not be a grave concern, because there are inbuilt checks and balances within the system itself. Let us assume in the Supreme Court we don't have a single judge bench. We have a division bench. It starts with a division bench. So let's assume that a particular bench goes wrong. So what? If it goes wrong, then it can be corrected by a larger bench. It can be corrected by which is happening also. So it is not, should not be a door. But so far as the concern about friction of the separation of powers is concerned, I personally don't think that's at all a cause of a concern. It's India is now a very mature democracy. Rather, it has, in its governance has been very so. The pros and cons, the positive side and the negative side ultimately is bound to prevail. So the truth and substance will always prevail. That has been my thought on the subject. So what your question is, that the bounds of the Supreme Court's activism. So I don't think there is any need to bind the Supreme Court by saying that you should not legislation. Of course, that's something very absurd to think that any kind of a check and balances would come through legislation. So, but that's not even a reason to feel concerned. And ultimately, if something comes up, so it's the majority will always prevail. And your question is also, I would say, I have very minutely looked into your questions, that I must put my answers within that bound, maybe because also because this is what you wanted the audience to know on this. And with an audience like this, I don't think we need to go into what exactly amounts to judicial activism, what amounts to judicial restraint, but the dimensions, and the possibilities which we need to feel concerned about is definitely one must debate, because like recently in some, I think maybe some online journal had put me some questions about this recent those COVID-19, when the Supreme Court took about the migrant laborers, some issues were raised in the Supreme Court. At least my view was that what is Supreme Court would only supplement, like if government is doing, because if something a very extraordinary situation is cropped up. So each organ of the state is trying to contribute what is being already done. Nobody is finding fault that the legislature or the executive did not do it, something which was required to be done. It's all a collective effort. So in the form of a collective effort, if you are trying to bring good, if you are trying to reform certain aberrations in the society, I think it's most welcome. At least I would, and even if, in my view is that even if you want to stop it, it won't. Because in those days, like in the 50s, if certain laws were not there, or judges were not so, as you say, activist, because there was no occasion. So as and when the occasion arises, the interpretations of Article 21, they are bound to be broadened. But broadening doesn't mean that, and I don't visualize a situation that courts will compel the parliament or the legislature to act in a particular way. Or like even in this euthanasia, we ourselves in two-judge bench, we had given that till the time there is an act on euthanasia, this court permission would be granted. And finally, the parliament itself took upon itself that yes, there will be a law on that. I think there are now, the matter is pending before the Constitution bench. So, but what the Constitution bench, what the courts never compelled. And I don't think whether it be triple talaq, whether it is Sabrimala, courts never, and views are bound to be different. Because merely because if some judgment is not suiting what I think is correct, I can't say the judgment is wrong. I say that according to my perception, it is not correct. But ultimately, the majority will prevail. And whatever is the substantial and the correct approach to a particular issue is bound to prevail, whether it is on the parliament, whether it is on the legislature, on the Supreme Court, or in the election process. Even while voting, if you have weight, you are bound to get it. So I don't think I should, if I have been not diplomatic in my views, I don't mind it, because I wanted to be candid in what I wanted to say, so that the audience may not beat about the bush what exactly the speaker is saying. Because if you want to be diplomatic, then it becomes difficult, how to balance the scales of justice. So, and there's no reason also, I mean, that of course for the lighter vein, there's no reason to be there. We must speak our mind. And differences, as they say, is bound to lead to the growth of law, growth of society, and building more energetic, I'm not getting the appropriate word, more mature democracy. For a more mature democracy, these dimensions are very good. So I don't think I need to add more on this. It was a pleasure, Pavan, interacting in your program. And I feel it's a great opportunity to be in touch with my lost but not forgotten friends, and more looking forward, and keep doing your bit. All of us should keep doing our bit And thank you for inviting me to this very interesting subject and the program. Thanks to all of you for bearing with my thoughts, and do let me know what more can we do. Of course, now outside the Supreme Court, I can't, write judgments, but commercial law, of course, I'm still writing judgments.
Thank you.
Thank you.
Thank you.
So thank you.
Thank you so much, ma'am.
Thank you, the eminent professor. Thank you, my ex-colleague. Should I say Mr. Venkataramani? What should I call you?
The judges would ask.
Thanks once again. Thanks.
Thank you. Thank you so much, ma'am, for giving deep and practical insight into the topic. And how suo motu proceedings started being considered as judicial activism, and also for making us understand that how in activism and restraint the view of judges differ in practical sense. Now, there are a few questions which I have received from the audience. Since we are already running the sort of time, I'll just ask one questions to each speaker. So first question is to Venkataramani, sir. So the question to you is, So the question to you is that whether Salem Bar Association versus State of Tamil Nadu case in 2002 or versus Union of India case in 2005 was the example of judicial activism or judicial overreach, because in those cases, Supreme Court did not struck down the amendment, but interpreted in such a way that it changed the entire amendment. Was it amount to create law rather than merely declaring the law? Sir, your opinion.
If you look at any judgment to the court where a virus of a law is involved, there are several choices open to the court. Either to disagree with the law, because on the plain language of the law is not constitutional, or it's somewhere in friction with the constitutional provisions. The other choice is to say that I uphold the law, because in our understanding, the law is in consonance with some constitutional provision of the other. A middle path sometimes chosen is where you say, I try to read down the law, right? Now, all these exercises are part of judicial review. It is not that one exercise is judicial review, the other exercise is not. Judicial review ultimately means to trace the contours of the Constitution and to superimpose a law on this and to find out whether there is a mismatch or there is a harmony. Now, there can be any small or big dimension where the court can find out and say, I disagree with this law. Therefore, all these debates are part of judicial review. These two judgments do not fall foul of this, the deliberative dimensions of judicial review. And if these laws were to have been struck down, let us say, now what would have been the context? Look at those legislations where tribunals being set up have been a long-standing issue in our country. Ever since the administrative tribunals have been set up. We had initially a 5-judge bench, later a larger bench, and today tribunals have become part of our, institutional culture or administration of justice. Regardless of what's called the mechanical way or then what called a serious non-application of mind in the drafting of the legislations. Because after all, you look at an IBC code, a tribunal for an IBC will have to be entirely differently composed, structured than a tribunal for a service matter. There are different dimensions. So a competition law commission, a different dimension. So if the law does not look at these dimensions, then the law is certainly bad. And what has happened is over a period of time, many of these legislation relating to tribunals have followed a mechanical pattern, right? Mechanical pattern where one law is borrowed and simply, put into another law. So there's a serious consequence for it. So that's why I refer to the IBC code. If you want a tribunal, which must look at issues relating to economics, finance, competition is a very important issue, right? And it's an important issue because on the one hand, we need to flourish, creativity to flourish, innovation to flourish. On the other hand, also alongside is the consumer's interest to be taken care of. But the other hand, competition, cartelization, etc. So these are economic issues and policies. And who will understand them better? Not certainly Mr. Venkataramani, right? So somebody else who needs to understand them better should be a part of the whole structure. What I'm saying is this judgment is correct, and then but it has not addressed certain other important issues as to ask the parliament or the government to say, look here, how are you really going to move into a next stage of tribunalization where the social, the intellectual expertise required for sitting in judgment and resolving different sets of issues ought to be brought into this whole framework. If you don't ask that question, the judgment is wrong. It's only to the limited extent the judgment is inadequate. But beyond that, I think the judgment is entirely in order, having followed the contours of judicial review. I don't find any fault with the judgments, but for this limited reason.
Okay, another question is to Justice Mishra, if I may unmute her. Yes. The question is, the use of power of contempt by the higher court has often been uncalled for and unregulated. There are more instances of abuse of the contempt power than its use. Whether judiciary is required a positive restraint from using these powers.
You see, it's a very tough question that has been put to me. You see, the restraint should be on both the sides, I would say. If I have to answer this, I would say that, you see, restraint should be both ways. What I have noticed in my experience is that most of the time, you might treat me as subjective in my view, but I have often expressed it even in open courts that the restraint or the values are not merely meant for the judges. Of course, judges, it is meant for the judges, but it is also meant for the lawyers and the litigants. So if you do not create a situation where we have to debate whether how much restraint should be used in the matter of contempt, then if becomes shortly put, like, if any kind of a comment, if any expression appears to be motivated, whether it's on the obviously contempt. When it comes to contempt, obviously the motivation comes either from the lawyer or the litigant, because the judge exercises the power of contempt. So ignite or the reason to use contempt power obviously emanates from the lawyer, litigant, many a times journalist also. So the journalist, it's making me slightly uncomfortable also how to be a little, at times I also need to be diplomatic, because if I अगर कुछ कहने पे चले आए तो तूफान उठा लेगी दुनिया. So actually it's, if you provoke and then the court also goes into the technicality, what is an individual contempt, what is an institutional contempt, whether a particular institute, because I also heard a debate after this Prashant Bhushan matter that such and such situation was not a this thing. So if, but I would not like to go into that that part. But I would say that, if everyone needs to introspect, a litigant, lawyer, and of course the judges, of course, one has to introspect. Judges, first of all, will have to introspect. Am I using the power of contempt to settle my scores because he has undermined my dignity? The lawyer also will have to deliberate whether I have done it innocently, just because I genuinely feel about it, or I want to teach a lesson to the judges. Litigant also will have to think whether I'm saying something because I have lost a case. The journalist also will have to say. Many a times I find journalists go to the extent of writing about a personal behavior of a judge, but they will never write about the judgments one way or the other. This subjectivity I do not know. So this objective approach, I say it with all conviction, that that objectivity is required to be meant for the judges, lawyers, litigant, as also the media. If you think, and why this situation comes up, because the judge doubts the lawyer's motive, the lawyer doubts the judge's motive, the judge doubts the lawyer's, litigants, media's motive. So ultimately, if there is honesty of purpose, so also I say, even in legislation, I've said this in National Judicial Academy and very candidly, and with a lot of that if you want to bring reforms into the system, like a Judicial Appointment Commission bill, if you want to reform the system, then do it that no one can at all question that this is for the reform of the institution. But if you want to capture power, whether it is the judiciary or the executive or the legislature, if you want to capture power, then it is bound to fizzle out. For example, if in the Judicial Appointment Commission, if I remember, the number of the persons to select the judges were not odd but even. I don't know. I'm slightly missing. If it were an odd number, sometimes I feel if it were an odd number, perhaps that legislation would have gone through. I don't know. I mean, there's a very sweeping generalization that I'm making. So now coming to the question which the questioner has put it, the honesty of purpose, if it is not exercised, then power of contempt is bound to be used, whether you criticize it or. But of course, the value of restraint can never be undermined in any walk of life, including like my daughter will say, why do you keep sermonizing the girls? And I said, no, the value that the women have got it, let me leave it at that. So because I often say कि जब कहने पे उतर आएंगे तो तूफान उठा लेगी, is my punchline. So it's better to.
Thank
so
you.
That is can you repeat what exactly he or she had said? Now
the question was whether the courts are required to restrain their power of contempt, whether there's a requirement, because the court frequently uses contempt rather than
definitely. So, my answer I would endorse it, yes. Like, and more for the courts. Like, if you are, because I come from a Hindi belt, so I'm with all those Hindi adages that come to my mind. Chama badan ko chahiye, chotan ko aparad. So the young ones are bound to, might create a mistake. But for the elders, the more restraint is required. That is how you can correct the younger ones. So yes. Rampant use of contempt would definitely neither in the interest of the institution or for any one of us. But restraint for all the sides.
Yes, thank you. Thank you so much, ma'am, for answering the question. And also would like to thank Ramani sir for answering the question which I asked that time. And now the last question is to Professor Dr. V.C. Vivekanandan. So the question is that judicial activism may be either positive or negative. Negative depends upon the person and social change. But at present, the stand taken by the Honorable Supreme Court and latest cases like Sabrimala issue, Kashmir issue, Ayodhya issue, etc., whether it's actually court exercises an activist role or it's a passive role by its stand.
Okay, see, the one is, as I said, that all three of us, as I said, I was laying down where it started and how it is there. As you say that a lot of water has flown down Potomac, Thames and Ganges. And then we are in a particular place now to look at our own Indian context and doing things. And that context, I laid down a few perspectives. In that context, I said judicial activism is a terminology which comes from political activism. When they say activism, we are really talking about something outside the organized structure in such sense. That is a character, what we call activism. He's an activist when you call. So when you come, that is now rephrased into judiciary, where people started using the term judicial activism, which is now part and parcel of the legal terminology, where they say that, are we just with what is precedent and what is that we are doing? Are we expanding and going? And many of you asked the question, PIL, which came with a letter, which even Justice, our advocate, senior advocate pointed out how it all started. So the question again, this whole question of judicial activism, judicial overreach is very difficult area to tell. As you said, it depends on time, it depends on individual judges at times, etc. But what we are really telling is basically what we are telling is that, is it so blatant, something is overreach? Let us take Sabarimala case you asked. I think the court, it comes to the court, right? After, it is not just a popped out thing. It came after a few things, it came to the court. So the court, means it was even explained in one of the meetings which we called Honorable Justice Deepak Mishra to Bennett University. The same question was asked by a student. His answer was about popular morality and a constitutional morality. And then they think at that point of time, the judges said they are upholding a constitutional morality, which may be variance with popular morality. And generally we know legislature, all that, as I discussed in many of the other people, thinkers, what they said is about how close parliament and legislature is close to the pulse of the people, and the whole mechanism is, not even, I'm not telling they are calculative, they are part and parcel of that emotion. And then when written laws and how judges look at it, etc., is from a different perspective altogether. They are, I wouldn't call, they are not unemotional, but they have a different sense of logic. They have to segregate themselves as a person, their beliefs, from what is in front of them to do the things. So if you take the question of Sabarimala, as you said, the original court judgment, what they said, was based on a long sort of thing which came and they gave the judgment. Now there is a review what they are putting. And as you said, which is positive or negative activism, if you look at anybody who is convicted, right, they are going to tell justice derailed. If anybody is released, they say justice prevailed. So that's what I said. Very interestingly, the word concept of justice, is singular for us, the word called justice. But it looks like where I am and how I am looking and how I am using the tool of law sometimes. So naturally, what we call as, there's a set of people who are going to tell more activism is needed. There are a set of people who are going to tell a lot of restraint is needed. And by the thing, which side you are in also decides. Which side of the line you are in and where your heart lies and what is your philosophy lies also matters in coming there. But let me tell you, activism is here to stay. And judicial outreach will also be critique. In fact, it was a very erudite Prime Minister like Mr. Manmohan Singh who first said about judicial overreach, which created a ripple at that time. And now, as I said, the new term is judicial underreach, which means there is judicial activism on things which need not be, and there is a judicial underreach where judiciary should have stepped in more. This is the kind of analysis which comes from scholars, society, everyone. Am I right? Okay. So I think all of this is going to be in front. There is no definitive, what you call a dictionary meaning or answer to these questions, in my opinion.
Correct. Thank you. Thank you so much, sir, for answering the question in such a beautiful way. So now we are on the verge of ending this session. Thus, on behalf of NEEF Judicial Education, I would like to thank Honorable Mrs. Justice Gyansudha Mishra, Mr. R. Venkataramani, and Professor Dr. V.C. Vivekananda for taking out time from their busy schedule and enriching us with their knowledge, wisdom, and experience. I also thank the audience for their questions and participating in the webinar. I also thank Dr. Vinod Sharma for being the backbone of NEEF Judicial Education. I further thank the entire team of NEEF Judicial Education for bringing such an impressive panel together. So thank you so much for your presence, everyone. Thank you so much.
Can we leave now?
Yes, ma'am.
Thank you. Nice meeting you.
Thank you. Nice meeting you, sir. Nice meeting you too.